Hi, this is Lee Phillips. I'm an attorney, and this is another piece in my series on YouTube about corporate formalities. What you do when you create and operate a corporation or a limited liability company. And the two animals are quite similar in their care and feeding. Well, assume that you've set up your company, you filed all the stuff with the state, you've signed everything they need, you've paid your money. Now, what happens? Well, one of the first things that you need to do is decide who's the owner or owners of your company. That may be you, it may be you and your husband and wife, maybe you and your partners, and I'm not calling them partner in a partnership sense, I'm just saying the people you work with in the company. But who owns it? Well, you need to define who owns it. Sometimes that's required in the Articles of Incorporation or the Articles of Organization, which are the papers you file with the state to create the company. But it's almost always required, or should be a good idea anyway, to include that sort of stuff in the bylaws, the rules of the game, if you're a corporation, or the operating agreement, the rules of the game, if you are an LLC. They're the same thing, but we call them by different names so that we know that's corporation, that's LLC. That should talk about who the owners are and what percentage ownership they have. And in a corporation, a lot of the times the corporation will keep all this, what we call treasury stock. No stock certificate issued, it's just mine. It's the company's. And in the LLC, they could keep back ownership by the LLC of a percentage or a number of shares of the ownership of the LLC. So you don't need to issue all of the shares at once. And by the way, one of the things that may be asked on the Articles of Incorporation is how many shares are you going to issue? If you issue 10 trillion shares, the state's going to charge you. You get the first 20,000 shares for freebie, state filing fees, and after that they start tacking on. And I don't know what the number is, it might not be 20,000. But they start tacking on additional fees. So you don't want to issue 6 trillion shares of stock. If I own the company, 1 share of stock is all I need. One of the things that I'm going to do when I get you into court and sue you is I'm going to say, okay, who are the owners of the company? How do you know that they're owners of the company? If you say, well, I'm the owner of the company. Okay. Did you issue a stock certificate or a membership certificate, is what we call it in an LLC? How do we know that you're the owner of the company? Well, it says it in the bylaws. It says it in the Articles of, or the operating agreement. That's fine. But I also want to see an actual stock certificate. If I'm going to invest in your company, and I'm going to be a third-party guy silent out there, I'm going to give you the money. What do I want back? Well, I want a stock certificate back or a membership interest certificate back, which shows, got a piece of paper, shows that I own X percent of this company, so many shares in this company. If you haven't actually issued the stock certificate or the membership interest certificate, then when I get you into court, I've got an argument. Your Honor, this wasn't a real company. They didn't even bother to define the ownership of the company. The guy knew he owned it all. It was his. No problem. It's his alter ego. I want you to let me pierce the corporate veil and go after the guy directly. So one of the elements that I'm going to be looking for in the lawsuit is, where is the ledger? You have a stock ledger, membership interest ledger, where you write down certificate number 1, issued on such and such a date to so-and-so for so many shares. And I want to see that ledger. And then I want to see the stock certificate, which goes with certificate number 1. And unless you haven't jumped these hurdles, actually done the paperwork, that's one indicia of the fact that, hey, you didn't treat this like a real company. Why do I have to treat it like a real company? And the courts will, if they stack up enough of these against you, they will do what's called pierce the corporate veil and they will come after you personally. So these little steps, none of them are fatal particularly, a couple of them are pretty close, but they all add up. It's the weight of the evidence. How did you treat your company? If you give IBM $100, you want $100 in stock back, don't you? Same thing. Think about it. How do I want my company to act? How do I want to be treated? And if it's third party, arm's length, we got a good chance of keeping the limited liability. And these corporate formalities, of which issuing the stock, the ledger, all of that stuff is one of them. It's these corporate formalities that add up, that either give the court the tip in your direction to protect you with the limited liability, or give the tip to the court in the other direction to pierce the corporate veil. So these are really important. Issue your stock, your membership interests.